Anyway, let's get to some other good news, okay? Supreme Court rules Alabama's congressional maps actually violate the Voting Rights Act. The Supreme Court giveth and the Supreme Court taketh. Now they're on their woke. They're doing the whole like, oh fuck, we went too far. We got to restore some confidence in the Supreme Court. Let's make it seem like we're actually, not a grossly undemocratic institution that refuses to champion civil rights. Let's get back to that a little bit.
The Supreme Court issued an unexpected ruling yesterday in a case involving black voters in Alabama. The mostly conservative court ruled 5-4 that the current Republican-drawn congressional districts in Alabama likely violate the Voting Rights Act by not fairly representing black voters. The state legislature will have to redraw the districts before next year's election. Joining us now to discuss this surprising turn of events is CBS News election law expert David Becker. David, good to see you this morning. So explain to our viewers, why was the state's congressional map so controversial in the first place?
Well, the Republican-led legislature in Alabama had drawn the districts, the 7 districts in the congressional map in Alabama, to include only one district in which black voters could meaningfully participate, in other words, to elect candidates that they chose. And that was a little unusual here, where black voters proved, in a state with 27% black voters, that they were entitled to more than one, likely 2 districts. And the lower court agreed with them. And in a state like Alabama, where we see what we call racially polarized voting, in other words, whites vote in such a way as to defeat black candidates of choice, it was determined that indeed black voters were entitled to that additional district. And here the Supreme Court agreed with them.
27% of the state is black. Almost a third of the state is black, and they get 1 representative. At least now they will get 2.
The maps going forward. However, the 2022 midterm elections, they're already in the books, so there's already been an implication in this case. In addition to the redrawing in Alabama, are there other broader implications in that?
Louisiana, baby. Every fucking racist, formerly Dixiecratic state is going to have this. This is like low-key, not even a joke. This is actually a big deal.
That state or nationally as a result of this ruling?
Yeah, one of the things that was really unexpected in this ruling is that we had seen this court erode and weaken and even eliminate some of the key provisions of the Voting Rights Act over the last decade.
I feel like it's crazy. This is an open admission that gerrymandering is a straight-up racist policy. Yeah, no shit. I mean, everyone knows it. It's just that in the case of Alabama, they went a little too far with it. So much so that, I mean, right place, right time, because the Supreme Court is trying to like clean up its image. So I think that probably factored into it. Like, I'm thinking about this because the Supreme Court is a conservative supermajority. Doesn't matter. Permanent supermajority at this point. They've done a lot. So I think like they wanted to come across as like impartial a little bit. This decision will net the Democrats, according to Dave Wasserman, possibly a +5 seat gain. New Cook Political, in the wake of the SCOTUS Alabama decision, we're shifting 5 House ratings in the Democrats' direction. It's very likely that 2 formerly solid Republican seats will end up solid D. Clarence Thomas's dissent. Clarence Thomas wrote a scathing, nearly 50-page dissent about why the Supreme Court should have gutted voting rights. Dude, he's fucking nuts, dude. Clarence Thomas, another like incredibly unique figure in American politics that like a lot of people don't fully grasp. I've talked about his background a lot. Actually, Chapo recently had someone on that like covered his background extensively, which is really cool because now I guess more chatters know about it. Because like every time I used to tell you guys he's like an anti-black nationalist, you guys would look at me like, what the fuck are you talking about? So now you guys get a better understanding of that, I hope. Yeah, Corey Robin. Yes, he is like a very unique guy and also is into bestiality. But that's a separate matter. It's like it should be illegal to have someone sit in the most prominent, like most powerful legal position, the most powerful judiciary position, the most powerful position as a judge, okay? And have that person openly admit that they got radicalized because of Thomas Sowell. If you say that, you're disqualified. Like, what are you, fucking a Sargon of Akkad fan? Like, what do you mean? You read Thomas Sowell and you got radicalized? That's crazy. But anyway, that guy wrote a 48-page dissent in the court's ruling that Alabama violated a ban on racial gerrymandering. Supreme Court ruled 5-4 on Thursday, holding a lower federal court's decision that Alabama violated the Voting Rights Act with congressional districts that discriminate against black voters in the state by largely clumping them together into one district. The surprise ruling prevented the court from gutting the Voting Rights Act of 1965, which, by the way, the Supreme Court already has. So this was going to be like the remainder of the Voting Rights Act. Like they were just going to say, like, no, it's done. It's over, completely over. Chief Justice John Roberts and Justice Brett Kavanaugh, both woke conservatives, as everybody knows, joined the Supreme Court's liberal-leaning justices in the ruling. Thomas was one of 4 conservative justices who opposed Thursday's ruling. In his dissenting opinion, he wrote 50 pages, dude. He wrote a manifesto. Thomas wrote that the court's decision has turned Section 2, the part of the Voting Rights Act that bans gerrymandering based on race, into nothing more than a racial entitlement to roughly proportional control of elective offices, limited only by feasibility, wherever different racial groups consistently prefer different candidates. Great decision overall from the Supreme Court, though.
And this decision put an end to that. This decision clearly established that the Voting Rights Act was constitutional, and that affects many cases nationwide. There are cases going on in Georgia and Louisiana right now where it's likely additional black districts will have to be drawn. It could affect some districts in Texas where additional Hispanic districts could be drawn. But more importantly, this isn't so much about the politics. This is really about the minority voters who are protected under the Voting Rights Act. And this is a case coming from the state, of course, where Bloody Sunday occurred. John Lewis was beaten on the Edmund Pettus Bridge in 1965.
Yeah, I mean, you touched on it briefly, but it was surprising considering the makeup of the court. The 5-4 decision, the court is primarily conservative. Does this signal anything to you, David?
It's not clear exactly what it signals. I mean, there are institutionalists on the court, conservative institutionalists. Clearly, Chief Justice Roberts falls into that category. Justice Kavanaugh falls into that category. And I think after weakening the Voting Rights Act over time, they wanted to send a message here. They just applied the law that had existed for decades to a very strong fact pattern. And I think that's a really good thing in this case.
Court deciding against a union at strike. So this case pitted a cement mixing company against its employees who they allege caused destruction of property during that strike. CNN's Jessica Schneider joins us now. So Jessica, break this all down for us. What happened here?
Yeah, Rahel, this is really the Supreme Court making it easier for at least one company in Washington state to actually sue union workers. So 8 of the justices here saying that a lawsuit between this cement mixing company and striking workers, it can continue in state court for now, even though the union workers here, they had argued that this suit should only be brought as part of a federal lawsuit. So this case has really been closely watched by supporters of unions. They've really, those supporters have really witnessed the conservative majority in recent years chipping away at the power of unions. This is yet another case where it does just that. So the cement company here wanting to bypass federal labor law and sue this union in state court for damages the company claims were caused by those striking workers. So to give you a little background here, this is a case stemming from a strike in 2017. Concrete drivers at this company in Washington state, they went on strike, and when they did, they returned their trucks fully loaded with concrete, so obviously rendering the concrete useless. The company was actually able to save the trucks, but they lost the concrete, so the company turned to sue the union in state court for property destruction. Now, the union obviously...
Yeah, so they left the trucks running, okay, when they authorized the strike. They left the trucks running so that the cement would not fucking, turn into full-blown concrete if it kept turning and harden and brick the entire trucks. Now, it's not cement, it's concrete, whatever. It's just like it's concrete, not cement. Well, as far as I understand the details of the case, they didn't actually fucking do anything other than stop working, which is what a strike is. However, the company took this as an opportunity to fucking go after them, which, by the way, they themselves actually stopped it. Like, they unloaded it themselves, which is why it's fucking ridiculous. Justice Amy Coney Barrett, writing for the majority, said the union failed to take reasonable precautions to protect the company's concrete when the drivers went on strike. Barrett wrote that the drivers for Washington State-based Glacier Northwest quit work suddenly, putting the company and property in foreseeable and imminent danger. That's not true, for the record. They actually did not. They actually did not fucking quit work suddenly. They very clearly and deliberately told the company, we're going to quit work at this time and date. The union's actions not only result in the destruction of all concrete Glacier had prepared for the day, they also posed a risk of foreseeable, aggravated, and imminent harm to Glacier trucks, Barrett wrote in a decision joined by 4 other justices. 3 or more justices agreed with the outcome of the case, but did not join Barrett's opinion. 2018, the court's conservative majority overturned a decades-old pro-union decision involving fees paid by government workers. I think, the Janus one, right? More recently, the justices rejected a California regulation giving unions access to farm property so they could organize workers. Justice Samuel Alito wrote in a separate opinion in the Washington State case that the Federal National Labor Relations Act protects their right to strike, but with limits. He said it does not protect striking employees who engage in the type of conduct alleged here. It absolutely fucking does. It no longer will. All matter of union action in the form of work stoppages is like deliberately done so that there is a loss of profit, okay? Because workers generate profit. So if you can't if you are going to have companies claw back that profit from union dues, okay, by suing the unions for engaging in any kind of work stoppage, then it's over. There's no reason to fucking do a strike. Strikes are not supposed to be conducted because your feelings are hurt, okay? There is a very clear definitional reason for why a work stoppage has any kind of power, any kind of bargaining power. That bargaining power is to show the actual fucking bosses that without the workers, will have no value. That's it. In her dissent, Jackson wrote, workers are not indentured servants bound to continue laboring until any planned work stoppage would be as painless as possible for their master. This case stemmed from the contract negotiations in 2017 between Glacier Northwest and local Teamsters Union representing the drivers. When negotiations broke down, the union called for a strike. Drivers walked off the job while their trucks were full of concrete, which must be used quickly and can damage the trucks if it's not. Glacier says the union timed the strike to create chaos and inflict damage. Glacier not only had to dump the concrete, but also pay for the wasted concrete to be broken up and hauled away. Oh man, sucks to suck. The company sued the union in state court for intentionally damaging its property. The lawsuit was initially dismissed, by the way. The question for the Supreme Court was about how the case should proceed. Glacier said its lawsuit in state court should not have been dismissed at the outset. The union said Glacier's lawsuit should only be allowed to go forward in state court if the Federal National Labor Relations Board first found that the union's actions were not protected by federal law. However, the Supreme Court decided, fuck the National Labor Relations Board. Who gives a fuck what they think? We don't give a shit. Don't bring it to them. Bring it to us, baby. We'll fucking undermine labor protections all on our own. That is our main and most important role here. Barrett wrote that because the union did not take reasonable precautions to protect Glacier's property, the trial court was wrong to think federal law required dismissing the lawsuit. How should workers respond to the Supreme Court's ruling in Glacier Northwest? The court's ruling could have been much worse and soon will be. Workers and unions need to be prepared. Today's decision leaves intact the long-held legal doctrine known as the Garmin preemption and therefore keeps the NLRB as the decision maker on what constitutes reasonable precaution in worker strikes. Cheerleaders for free enterprise were hoping to replace that long-established federal jurisdiction with state-level tort law. Those cheerleaders didn't get all they wanted today. The bad news, a harbinger for the future, is on full view in Justice Samuel Alito's concurring opinion, where he makes clear that he is ready and willing to kill Garmin as soon as the court can get a better case with which to achieve this Chamber of Commerce objective. He's joined by the other hardcore anti-labor ideologues on the court, Justices Thomas and Gorsuch, in a second concurring opinion, revealing their hands clearly so we can count. 3 justices are ready to totally eviscerate the NLRB as a part of their determined campaign to gut the administrative state. Agency by agency, they're progressing when they get the chance, as we saw this court just do so just last week to the Environmental Protection Agency, all but stripping it of any power to at all enforce the Clean Water Act. Once these 3 do get a better shot in a less procedurally layered case, they will take it, and workers in the NLRB will not escape the full force of this agenda. What the court did today, in essence, was simply say workers can't call surprise strikes that cause property damage. What's coming is much worse, and its potential implications so dire that it's worth not only unpacking this ruling's highlights, but also focusing urgently on strategy for the labor movement as a whole on what the workers can and should be doing right now. Glacier has its origins in the 2017 contract dispute. We already covered all that. On its face, Glacier is about whether the Teamster Union owes money to a Washington concrete company, but the real purpose of pushing this case was to append the nearly 100 years of legal precedent and congressional intent by stripping power from the NLRB, the federal agency charged with protecting workers' rights to collective action at work. Exactly. Under Garmin, if a lawsuit is brought to the state court over conduct arguably protected under federal labor law, say nonviolent peaceful direct action by workers, the state court must defer to the NLRB's determination of whether the conduct was in fact protected. This lets the federal agency responsible for handling thousands of labor disputes every year decide which actions by workers are protected by the NLRA, rather than some random state court judge, most of whom hear only a few labor cases a year and have little to no expertise on the field. Pre-Gammon, State court interventions in the labor disputes were almost uniformly disastrous for workers and unions. Shocker. Creating legal uncertainty, fear, and a tool for employers to impose ruinous liability on workers taking collective action. The Washington Supreme Court sided with the workers, by the way. Well, they dropped it, I thought. Yeah, they said this needs to be dealt with not by us, but by the NLRB, which is what is supposed to happen. That is quite literally the fucking law. That is the rule. You know, back when Congress did like every now and then some shit, this is one thing that they fucking decided. But what do you expect? This is the same Supreme Court, well, nearly the same Supreme Court that said Nestle can continue using slaves, child slaves, and that those child slaves cannot actually ask for any kind of restitution or any kind. They have no legal recourse because, sorry, Nestle subcontracted out the child slavery. So therefore, it's not up to Nestle to, Nestle could have never foreseen that their subcontractors were using child slaves. Yeah, protect our children. If you want to protect our children, how about you think about the children that are fucking working in like Alabama Hyundai factories? You know what I mean? How about you protect the children that are going to be working legally in places like Arkansas, where they are currently unwinding child labor regulations.